Item 701.
But before my learned senior starts, there is a small request. Regarding the scope of the reference. As your lordships, my lord, have now broadly, my lord, seen the papers. My lord, the reference is whether Article 30, sub-article 1, the expression used, establish and administer, is disjunctive or otherwise. Where, my lord, Aziz Pasha will have to be, my lord, addressed. But the written submissions which all of us have received from the petitioner is as if Aziz Pasha is being reconsidered, as if this bench is sitting as an appellate bench. My lord, I have, my lord, in my written submissions,
My lord,
narrated. Only a minute, if I
the
can.
capacity of the solicitor to interrupt and take the stage is legendary. Let us begin, and he will answer, and we will answer him. This is not on, my lord. This is simply not on. If he has raised certain questions, we will answer them.
Let Dr. Dhawan open, because once in about 20 minutes, we'll know what the ambit of his submissions is going to be. Then we will see as the matter progresses. Let Dr. Dhawan open. Let Dr. Dhawan open.
Let us begin,
This
my
is
lord.
our request, and we have decided to be, my lord, decent, and we will be.
Both individually on the issues, quite apart from being disjunctive or conjunctive, that's one part of it. But on the individual issues under Article 30, whether Aligarh Muslim University was administered or, let's read and as or established, on both those issues, the court ruled to say that it is neither administered by minorities or established by minorities. That correctness of the finding has never been referred. Has ever been referred. That's all that we wanted to point out.
My lord,
That will be
whether the reference is
that will be your
sustainable.
submission. That will be your submission in this.
Lord,
Yes, that's all.
My lord, whether this reference is sustainable is an argument I'm going to make.
Because in fact,
Because one
proceeds
curiosity.
the premise that these.
What is
referred
this,
order-
Lord? I've never seen this in the Supreme Court.
Mr. Guru, we are now
I've
before
never
a bench of seven. We are a bench of seven. Let Dr. Dhawan open his argument. As the matter progresses, we'll understand what is the scope of the controversy, and then we will decide where.
This is simply unfair.
Yes, Dr. Dhawan, we'll
In,
start.
in fact, it is fair. We know
No,
that
please,
what is the
Please, one person goes on air, Basha, the other person says the reference is not maintainable. We will address these issues.
You won't be able to.
You answer.
Let us leave
You
it.
answer, and we will answer you. My only request, my lord, is this.
Yes.
There is a certain slack we might require in your lordship's timing. We appreciate, my lord, that this is the busiest court in the world. You are overwhelmed in a way in which no court in the world is overwhelmed, whether it's 136 or whatever it is. The time that your lordship can give, Lord, is very important. And I would just say that in the light of what has been said, our reply is important. In the 370 case, our reply was curtailed, my lord. If required, your lordship may give us time. That's my respectful submission. My lord, I remember G.L. Sanghi was asked to curtail his arguments. Krishna Iyer rang him up in the evening and said, your item is number 1, please continue. These are, my lord, traditions, and I know that the Chief Justice, and I've commended it, is so patient in listening to arguments. It is admirable.
Dhawan will thank you. Don't worry about the fact. Ultimately, our conscience has to be satisfied that we have heard both sides fully.
Right, and our reply.
The reason why we set down time limits is because then people have a broad indication.
Lord, I understand.
There's no
I understand
repetition
the
by
need for time limit, my lord.
Yes.
Your lordships are overwhelmed. Now, my lord, let me begin by saying about the reference. I want to read the 2 reference orders to your lordships, because the significant thing in the 2 reference orders is this, that normally when a reference is made, the points of reference are itemized by your lordships. This has not been done in this case. So I've taken the liberty, my lord, in my written submission of itemizing what draws from the 2 reference orders, the first in 81 and the second in 2019. So let me take your lordship straight away to those two particular orders. Because it's important your lordship should itemize what the point of reference is.
We get them in volume 3A, right?
3A, absolutely. Show me both, 209. I'm sorry, I'm a Luddite, my lord. I'll have to use the printed text. So much better. One day, my lord, I will learn. That's a promise. My lord, kindly turn to.
I thought we could have started with this matter.
It should start with this matter. I'm learning, my lord, I'm learning.
Hello.
I am. I appreciate this, my lord. And when I interact with my colleagues, they're brilliant at this in a way in which we never were. Anyway, kindly turn to, what is it? That's the PDF? 209. Well, this was what said by a bench presided over by Justice Fazal Ali. It says, after hearing the parties, we are clearly of this opinion that this case involves two substantial questions regarding the interpretation institution changes in view of the broad principles laid down in Aziz Basha. Even as several jurists, including Mr. Sirwai, have expressed the correctness of the decision of this court. Since the point has arisen, we think that it is proper with a larger bench can consider the aspect fully. We therefore direct that this case may be placed before the Honorable Chief Justice for being heard by a bench of at least 7 judges, so that Aziz Basha may also be considered and the points that arise directly to the essential conditions or ingredients of the minority institution may also be decided once and for all. Then a reference is made to the various criticisms which the court noted. A large number of jurists, including Mr. Sirwai, learned counsel for the petitioner, Mr. Garg, and interveners Dikshit and Taskar, have also stated, Mr. Garg and interveners Dikshit and Taskar have also stated that this case requires reconsideration. In view of the urgency that this matter may be decided as early as possible, we gave liberty to counsel to mention it before the Chief Justice. So here, my lord, is a clear statement. Of course, that reference was not made eventually. But we have now to consider the reference that was made by my Lord Chief Justice Gogoi. Your Lordship may come to 216. The point I'm going to make is there are so many things mentioned in this reference that your lordships will have to formulate, and we will assist your lordship to formulate what the points of reference really are. Maybe all these arguments, the reference is bad, etc., can be looked at after the event. Now, my lord, 216 begins with Aziz Basha. In our mind, it's clear that the community will have the right to establish an administrator of their choice, meaning thereby where a religious minority establishes an educational institution, it will have the right to administer it. An argument has been raised to the effect that even though the religious minority may not have been established, it will still have the right to administer. When I get to Aziz Bhasha, my lord, I'll read all of it, but kindly come to page 218. It's a very interesting comment, my lord, your lordships have made, which really, in a sense, takes us much further, where in paragraph 2, it is said the judgment of the Allahabad High Court, which is under challenge, rejects the prayers made on account of the decision of Aziz Bhasha. This is the effect of Aziz Bhasha. That after 1968, it has quelled all understandings of Article 30. Then, my lord, a mention is made of Anjuman Rahmania, which is the 1981 case. And then, my lord, your lordships will see in paragraph 4, it mentions TMA Pi. What is the effect of TMA Pi? It's crucial, my lord, in our understanding of what this is. Your lordships will then come, my lord, to page 219, where a question was raised in TMA. Now, Yashpal, my lord, looking at the UGC Act, which Aziz Bhasha refers to, but nevertheless, it does. UGC Act, my lord. Now, my lord, what do we do with Yashpal? And then, my lord, over the case 221, having regard to the background as stated above, when the precise question was already referred to the 7-judge bench but not answered, we are of the view that the present question set out above should be referred. Now, what is to be taken into account, my lord? TMA Pi is to be taken into account. Yashpal is to be taken account. Yashpal, my lord, says that when you want to establish a university, it has to be done by statute. This is section 23 of the UGC Act as well. Now, the point would be, it means that wherever there is the establishment by statute, you are not entitled to be a minority institution. This will affect a large number of institutions, my lord, in this country. Your lordship is a chancellor, my lord, I want to stress that point because I don't think Aziz Bhasha has understood how universities are administered. Now, my lord, what do we do with the reference? You can pop up and say whatever you like, but we have tried to make, my lord, some sense out of what this is. I've done it in a small paragraph, and will your lordships come to my written submission? Lord, my learned friend says that in 220, Aziz Bhasha has to be reconsidered is mentioned twice. This is there, my lord, in the reference. But unfortunately, that bench did not delineate what the questions are, which normally, my lord, happens. Now come to my written submission.
Of course, the order, the referring order by Chief Justice Gogoi, Brother Justice Khanna, and Justice Nageshwar Rao refers to the questions which were formulated in Justice Fazal Ali's original order. Says that, well, those questions were never answered. No.
Question formulated is TMA.
No, there were two questions which were formulated by Justice Fazal Ali. In fact, he began by saying two questions arise.
Yes.
He didn't formulate them as 1 and 2, but it's obvious on the first page the learned judges formulated the two questions.
But the very fact that it refers to 2MA Pi and Yashpal has to be taken into account, my lord. It's as simple as that, my lord. Now, my lord,
These
finally,
questions were formulated by Justice Fazal Ali is referring.
to some extent, my lord. to some extent. But this court looked at the later decisions of this court.
And the later developments which have
That's
taken
right.
place as well.
Now, my lord, kindly come to my written submission. This is volume 1A.
Because you have the 2004 Act which comes in, then Yashpal is there.
That's right,
And then TMA Pi tells us how do you define a minority? It doesn't
That's
tell,
right.
TMA Pi doesn't deal with establish and administer, but it certainly has some bearing on the issue because it does.
Of course, and its consequences. Because your lordships are always concerned with the consequences of an interpretation. Kindly come, my lord, to my written submission.
That would be volume
The 1A.
1.
But kindly turn to page 7, where I've summarized, I'm sorry.
So Dr. Dhawan?
Now, my lord, after what I've read to your lordships, I've dealt that. Kindly come to page 8, 1.5. To my mind, my lord, since Yashpal, and of course there's the National Minorities Act, my lord, which is very important, I have, my lord, indicated what the possible reference could be. And that your lordships will find at the bottom of page 8. May I read it, my lord?
Yes.
Now, my lord, at the bottom of 8, I've succinctly put what the reference should be. Whether the decision in Aziz Bhasha is internally contradictory in its reasoning on facts and law, contrary to the authoritative decisions of this court, rendered nugatory by subsequent statutory changes, and contrary to the constitutional dispensation of Article 30. This covers, my lord, the later portions and the earlier portions. Now here, my lord, I put the issues that arise from this. The first is, was Aziz Bhasha correctly decided, and whether it suffers from internal contradiction and reasoning on facts and law? This, my lord, I'll place Aziz Bhasha before your lordships. Did Aziz Bhasha need to be considered in the light of earlier and subsequent decisions of this court? What is the effect of Aziz Bhasha in the future decisions of the Allahabad High Court, which applies Aziz Bhasha completely and strikes down the statutory amendments through the 81 Act? My lord, when we went to the Allahabad High Court, Chief Justice Ray simply said, this problem of Article 30 and Aziz Bhasha is by a bench, authoritative bench. We have to follow it. There's nothing more we can do. Of course, the judgment is piquant, but we are not at present, my lord, in appeal over the Allahabad judgment. I appreciate that, my lord. We can certainly place it before your lordships, but I don't think it's necessary. Maybe that's in the light of your lordship's decision. Maybe, my lord, that can be done by the smaller bench. Now, my lord, what is the effect of the National Commission of Institutions Act read with the University Grants Commission? Should Aziz Bhasha be reconsidered in the light of the NCMI and read with UGC by Yashpal? Then, my lord, was Aziz Bhasha correct in accepting the antecedent historical data on AMU's Muslim character, but denying its constitutional significance while deciding the issue of its minority status, which is at variance with St. Stephen's, Proust, my lord, and Pathak. Then is Aziz Basha contrary to the constitutional dispensation? My lord, that's the sixth point. These are the issues that arise, and I've dealt with them in seriatim. Because we have to, my lord, whether we like it or not, cull a reference from the two reference orders. Now, my lords, I want to begin by saying, before I go into the preliminary objections that we want to raise, my lord, Lord, I think your lordship will bear in mind that India has a diversity which is more than continents and any other country in the world. Your lordships have listed they've listed only 22 languages in the 8th schedule, but in actual fact, there are much more. As you go across even my state of UP, you will see the variation as it goes, and they want to preserve that language. Tulu, my lord, that is the basis of TMA PIEs. Therefore, your lordship will bear in mind that this enormous task before your lordships, which TMA PIE squarely places in talking of secularism, and then there's this very elegant passage, my lord, at the end. Very evocative, my lord, but very important. So when your lordship gets into this question, my lord, your lordship is deciding something that goes to the heart of Indian secularism and to the heart of the diversity of this country, both in terms of language as well as religion. This is so crucial to our understanding of the Constitution. Of course, in 1920, there was no Constitution. But subsequent developments have taken place. In 1950, a Constitution comes. 56, the UGC Act comes. The Minority Act comes. And there's a load of decisions, Lord, which say, look at the historical antecedency. Aziz Bhasha looks at it and says it's now irrelevant because we have decided that the Act, in fact, established. What happens to that rich history, my lord? Mr. Sibal will also comment on it. What happens to that rich history? Throughout the world, my lord, there are minority state institutions. Your lordship went to Harvard. John Harvard came from Emmanuel College, my college, my lord, and we still exchange with Harvard. If you look at America across the board, and if you look at India today, private institutions and minority institutions are the heart and soul of Indian education. You can't deny it, my lord. And that is why Justice Kripal says, so what if they're aided? They don't lose their minority character. You can't withdraw recognition. This is one of the points that is made in TMA PIE. To its pleadings and affidavits in the present litigation in the absence of any change in circumstance or new material. The Union of India, my lord, has always defended the statute. In Aziz Bhasha, they defended the 1951 and 65 Act. And when we were in Allahabad and before this court, when your lordship gave a stay order, the Union of India took the view that Aziz Bhasha was wrongly decided. The history should have been taken into account. And how can it change its stance? How can, because of a regime change, how can, my lord, we say that because of the regime change, we change our stance? It can't be done, my lord. I await, my lord, the solicitor's response to all this. And when that response comes, we will reply. But just let me take you to one or two passages on page 10 onwards. What the Union of India does, my lord, in 2.2, in view of the foregoing paras in general and particularly in view of the judgment of the Supreme Court in Aziz Basha, the Union of India has decided to withdraw its earlier stance taken by the government to support the minority institutions status of Aligarh Muslim University. The SLP filed in the Supreme Court in 2006 in support of the minority status of ANU may accordingly be treated as withdrawn. Now, of course, your lordship has to give permission for this. That hasn't happened. We've responded to this as well. Then, my lord, your lordships will see, I've said the Union of India's volte-facing. We have taken, my lord, the petitions have been opposed by the Union of India, and its main contention is that the Aligarh University, established in 1920 by the AMU Act, and that this establishment was not by the Muslim minority, but the government of India by virtue of a statute, the 20 Act, and therefore the Muslim minority could not claim any fundamental right to administer. So if you're not established, the question of administration doesn't apply. Sorry? Yes, my lord, in Aziz Bhasha, they defended the statutes. Now there is a change of regime. Till 2005, they take the view that this is right. Mr. Gopal Subramaniam, my lord, appeared in the Allahabad High Court, both for the Attorney General as well as the government. He came here, my lord, we came before your lordships. The stance, my lord, in the stay order, at which some stage I will show your lordship, was no, Aziz Basha is wrong and the judgment of the Allahabad High Court is wrong. So your lordship said that as far as the reservation is concerned, stop it. And AMU agreed. But as far as the other things that you do, that is within 25 miles of the kilometers of the mosque, you will keep your minority institutions and Muslim institutions intact. Then, my lord, over the page, and this I reserve for my right to reply, I've given two decisions as to whether the stance of the government can be changed or not. And the decisions basically say, if there is a policy change, it's different. But this is more fundamental. There's a constitution in place here. And, my lord, it's idle to argue that before this that took place. Now, there is some discomfiture in the select committee, which Justice Vanchu, my lord, points out. But the select committee majority takes an entirely different view. So, my lord, our view is that the Union of India stance is a defiance of the Parliament's recognition in 1981 that AMU is indeed a minority institution. It's contrary to the pleadings and submissions made before the Allahabad High Court and this honorable court. Now, my lord, I needn't remind your lordship of Sanjeev Coke, which says that mere affidavits, my lord, will not solve the problem. Then, my lord, I sum up in 2.12. It is the duty bound to defend and follow the will of Parliament expressed in the 1981. The Union of India is not going to defend it, having defended it. Then, my lord, it failed to file a justifiable ground for reversing their consistent stand since 1981 at the governmental level and before the Honorable Court and the Allahabad High Court. In these very proceedings, its failure to state that any new material or legal developments to justify this stance is arbitrary, reasonable, and I'll go to it on merit. Starting with Aziz Basha. But before that, my lord, may I take your lordships to Article 30. Constitution. My lord, the heart and soul of secularism as far as minorities is concerned. Minority protection started in 1909 when reservation was made, 1919, 1935, and of course our constitution. Now have a look at the importance of Article 25 to 30. This is the crux of the understanding of what has to be done in this multi-diverse country. Because take away the diversity, there are all kinds of assimilations that are at present taking place, my lord, in our country. But take away this particular aspect and the entire color of our constitution and governance changes. Now, my lord, kindly come to 25. ऐसे यार कहीं ना कहीं मिल जाएगी दे दो ठीक है Now, my lord, 25 and 26 are important. And Aziz Basha went slightly wrong, my lord, in its understanding of 26. In Justice Kripal's judgment of TMA Pi, he says 26 will also give you a right to establish institutions. Aziz Basha says, since you're out in 30, how can you have a right under 26? Now, my lord, there are two concepts of secularism, my lord, in our constitution. The first comes from 25(2)(a), where it says regulating or restricting the economic, financial, political, or other secular activity which may be associated with ritual practice. This is where secularism is mentioned. And this is the negative view of secularism, saying that these rights will be subject to secular. This is a very narrow view. The wider view that your lordships have taken on secularism, my lord, which is writ large over your lordship's decisions, is what we understand as part of the basic structure. The narrow view, my lord, simply says you can regulate this activity. Then, my lord, if your lordships, I've taken you through the 26, 28(3) is important because it mentions aid and that you cannot, because of the aid, that there are some limitations on what you can do. This is now fully explained in TMA Pi and not fully explained in Bhasha. Now, my lords, kindly come to Article 30. I'm not going into the controversies, my lord, of 29 and 30, that 29(1) is a limitation on 30. All that has been decided. It's not. Now come to 1A, we needn't bother about that, my lord. But the main provision of 30, all minorities, whether based on religion or language, this is the diversity provision, shall have the right to establish, this is important, establish what? And administer educational institutions. Now, this has to be read conjunctively. I have no doubt about that. But one point that your lordship should notice is this. What is a minority is something anterior to this. Established and administer are the rights that flow from the recognition of a minority. It's very important, my lord, that your lordship should settle this. Now, my lord, what is it that makes a minority? In my view, my lord, there are three questions. Firstly, the question of origin. Did the origin come from, and where mother provincial effectively is in contrast? I'm sorry, one gets a little excited. Mother provincial says it does not matter even if a single financier comes in para 8, which I'll deal with. That's enough. All this Aziz Bhasha business of not ignoring the antecedency, my lord, is wiped out. The second question, my lord, is the question of nexus, where mother provincial and other decisions take the view that what you have to look at is whether they found the institution or not. And thirdly, my lord, is the numerical test in TMA Pi. Kerala education did not answer that question. We now know that the numerical test is in respect to the state. Of course, some of us who argued Pi and Rod are not particularly happy with this, because we support Justice Uma Pal's decision that it depends on the nature of the statute. But in any case, the majority has held this. Then over and above that, my lord, we have to look at the intention, my lord, of the statute in question. What Aziz Bhasha does, my lord, and I'll take your lordship through the statute, it ignores the purpose of the statute. The purpose of the statute is writ large that it is of a Muslim character. Whereas it goes into the question of establish and administer, it ignores the purpose altogether. Now, my lords, I'll briefly, my lord, indicate to your lordships what my broad argument on Aziz Bhasha is going to be. My lord, Aziz Bhasha is, I'm sorry. Yeah. Lord, it is always the wish of arguing counsel to know what your lordships were whispering about.
Nothing about to some diversion, in a way connected with the matter.
Of course, I realize. Even more so, my lord, even more so. One thing that I didn't, my lord, emphasize in Article 30 is the words of their choice. Now, my lords, I'll briefly outline first what Aziz Basha does, my lord, and then take your lordships through the decision.
Of their choice was introduced to indicate that you can have a perfectly secular education being administered in a minority institution.
Yes, yes, of course.
Therefore, you're not constrained to only propagating your religion or your language or your culture. You can have an engineering college. You can have an IT college. That was the purpose.
What your lordships have done is added two caveats to this. Because there was a fear that these institutions will become too insular. I think that's your lordship's point. Don't just talk about that. What your lordships have done, my lord, in Siddhaj Bhai and in TMA Pi, is your lordships have said that these institutions must be institutions of excellence. That's very important, my lord. And AMU and all the, my lord, our understanding of the Constitution is you must, whatever your minority character, must be institutions of excellence.
Therefore, the court has held that any regulation which promotes the character of that institution as an institution of excellence is permissible.
Of course.
So therefore, you must pay minimum salaries to your professors,
Yes, yes.
because that, if you don't, they will not be an institution of
My
excellence.
lord,
That's how we have justified
the
it.
other caveat, my lord, in
Frank Anthony, for instance.
a lot of decisions is this, that where the ordinary law applies, service law, electricity law, whatever it may be,
There's no immunity from the application.
there is no immunity from that. And I make it absolutely clear that AMU and the other institutions must be institutes of excellence. It goes to the core of raising the level of minority institutions. And your lordships have done this consistently on these 2 points. Institutions of excellence and ordinary law will apply to you. But the moment you say recognition will not be given to you, TMA Pi says this is not wrong. Funding, affiliation, my lord, all that will be impediments. I must say, my lord, that in accreditation, AMU has been given A1, A plus in its excellence. Now, my lord, my first point about Aziz Basha is this. Aziz Basha says universities can be a minority. This is at page 848. I'll take your lordship's through it. Now, if universities can be a minority, and you say that if they are established by statute, they have no protection, this is a contradiction. Because now, my lord, as ever, universities can be established in only 2 ways. Royal Charter, which doesn't apply, applies to high courts but nobody else. And, my lord, statute. Section 23 of the UGC Act, which is noted by Aziz Basha, says it must be by statute. At the same time, it takes the view that if you are statutorily established, then you are established by the statute and not your antecedents. The second, my lord, is Aziz Basha, my lord, recognizes the background and antecedents role that the MAO College made in building this institution. This it does at page 849. I'll show to your lordships. And it is said, my lord, it is clearly Muslim. The third point that I want to raise before your lordships, because I want to take your lordships to the Act of 1920 and of course the Act of 81. It ignores completely the purposes of the Act. So all the provisions that actually deal with its Muslim character are totally and completely ignored. Now, my lord, there is one thing, and your lordships will appreciate that. Aziz Bhasha, my lord, does not wholly understand how universities are run. It mentions the Governor General, it mentions the Rector. Universities, my lord, have a dual system. Firstly, and your lordships will appreciate this as Chancellor, and this is that you will supervise if necessary, you will inquire. All that is written, my lord, for example, in section 7 of the Bangalore. It is there in NUJS, it is there in Sanchi. So one aspect, my lord, is the external institutions that are kind of suo motu ombudsman. The second part is the statute itself and the institutions of the minority. The emphasis in Aziz Bhasha that the rector has this enormous power, my lord, is unfounded. In all universities, the rector later became the visitor. In all universities, the chancellor, the rector, or the visitor has this supervisory power, and that will not, my lord, interfere at all with the minority status. My next point is, my lord, that Aziz Bhasha ignores the alternative meanings to establish. This is relevant for our understanding of mother provincial. It also understands but misunderstands the importance of recognition. It says recognition, why is that? That takes everything away and you become really nothing more than an institution of government. These are the broad arguments, my lord. Because Aziz Bhasha takes a very narrow view of Article 30. Now, my lord, may I take your lordship to Aziz Bhasha? It's volume 3, lord. 3A. Will your lordship turn to 3A? We feel, my lord, it was so much better to hand over the books.
So much better this way.
I know, my lord.
There's no time spent in handing over books,
No,
returning them.
but the point is, one went straight to the point, and then the books came out, went into the. So there was a continuity that we had, which is somewhat broken, my lord. But that doesn't matter, my lord. I told your lordships I'm a Luddite and I'm amazed at your lordships' dexterity. Now, my lord, page 3 of 3A is where the head note is. From the head note itself, which I won't read out, but I'll read from the judgment. It goes into the antecedent history and says it's very important, and then ignores it because the 1920 Act is there. But let me take your lordships, my lord, to the judgment itself. Now, my lord, page 7. The Union of India's stance, my lord, was that it's not a minority institution, but also it defended the statutes of 1951 and 65, which were before the court. Now, my lord, there have been further developments. We have the 1981 Act. How can you now say the 1981 Act? I mean, I can understand that the Allahabad High Court knocked down 3 provisions of the AMU Act because they said it was a usurpation of the judicial power. Now, my lord, the Chief Justice has dealt with this and Pavitra too. I won't go into greater detail about it. No? Did the 81 Act change the basis, or was it a usurpation of judicial power? in knocking down the preamble and two sections, which I'll show to your lordships. In actual fact, they said it's a usurpation of judicial power, and it's not honest. Now, my lord, kindly come to page 8. Here is the history of the establishment, and it says it's necessary to understand it. I'll give your lordships a fuller account. I won't take your lordships through it. Now, 1870, Sayyid Ahmad Khan says the Muslim community is neglected. Then, there's a whole list of negotiations, which I'll show to your lordships. He wanted liberal education to Muslims. Then he says in 1872, the MAO was established. And then, my lord, in sequence of activities, a school was opened. Then Lord Lytton laid the foundation stone. The MAO College was established thereafter, and it is a flourishing institution by the time of Sayyid Ahmad Khan. Then, my lord, at the bottom of that page, and your lordship has to see that, long negotiations took place. That's the last 3 lines on that page. Between the association and the government of India, which eventually resulted in the establishment of the Aligarh. Now that is the antecedent history. We have to review it in the light of my Lord St. Stephen's. The antecedent history is important because your lordships will see that even St. Stephen's was in fact a constituent college under a statute. All our deemed universities are actually, as Mr. Dwivedi pointed out to the court in Yashpal, are and under a statute. If Aziz Basha is taken at its limits, it could destroy the entire system. Now, my lords, it is mentioned that before a large sum of money was collected by the university, as the government of India made it a condition that rupees 30 lakhs must be collected for the university before it could be established. Further, it seems that the existing MAO college was made the basis of the 1920 Act for the administration of the university, along with the properties and funds attached to the college, the major part of which was contributed by Muslims. This is the antecedent history, and Justice Bancho recognizes this. But he says, I'm sorry, the 1920 Act, they'll go by the establishment, and that's the end of it. Then, my lord, the preamble says it is expedient to establish and incorporate a teaching and residential Muslim university and to dissolve the societies under the Society Registration Act, which are known as MAO. Aligarh and Muslim University transferred to vest in the university all the properties and rights of the said societies and the Muslim Universities Foundation. Now, this is important, my lord, because a continuity was established between the pre-1920 Act and the 1920 Act. This continuity is fundamental to our understanding. Justice Bancho realizes this, but then ignores it. Now, my lord, kindly come to section 3. It also mentions, my lord, opposite place H, that section 4 dissolved the MAO College and Muslim University Association and all the property, movable, immovable, and all rights and powers of the privilege were, my lord, were transferred to Aligarh. This is the continuity in section 4. How can you ignore it? MAO is now being transformed by section 4. Of course, my lord, earlier, because of section 23 of the Act, the court, which was a big body, had almost its own leader. That was amended in 1951. Now, my lord, over the page. Now, my lord, kindly come to place C. These provisions will show that the three previous bodies legally came to an end and everything that they possessed of was vested in the university by the 1920 Act. Of course it was, but the continuity. And nowhere you will see in the Act, as I'll show to your lordships, the Muslim character. Section 6 is important because Justice Manchu finds fault with the fact that the degrees, etc., will be recognized by the government. This is precisely what your lordships have said in Kerala Education and others. Recognition must be given. Then, my lord, your lordships will see 13. 13, my lord, as I pointed out, is a misunderstanding of university education. Because university education, my lord, is based on two templates. The external template, which is chancellors, visitors, visiting board. And then it is provided that the governor shall be the Lord Rector. This becomes visitor later on. And then it mentions at the bottom of the page that the Lord Rector shall give notice to the university of its intention to cause an inquiry.
You said university education is based on two templates. One was the external.
And the internal.
And the internal would be the internal management of the university? How would you define it?
Read, my lord, how the university runs. This template is important. And I might mention, since your lordship, Lord, is a chancellor of these universities, look at section 7 of the Bangalore Act and the Calcutta Act. They're similar. Then, my lord, your lordships will see section 14, which is now no longer there. But the important point, my lord, is at E. I'm sorry, my lord, my learned friends want me to read C. The provisions clearly bring out the final control. It's not a final control. In the template, it is a supervisory control. May I sit down for 2 minutes, my lord?
You, Mr. Dr. Dhawan, there's no difficulty. You don't have to stand and argue.
I noticed that Mr. Parasar and your lordship said he could sit down.
I know, I remember that.
And he said no. So I must resist, my lord, and suffer this up to lunch.
You can sit down, doesn't matter.
Dr. Dhawan, this is because of your lower back issue. Please sit down and please sit and argue.
Yeah.
That's perfectly fine.
Aggravated. It might aggravate.
Yes, thanks, argued.
Out of concern, I'm saying.
And you can move the podium aside. You can move the podium aside and you can have a seat and
Mr. Parasaran didn't have the back problem. You
you
can.
can come on the side and
Thank you.
in fact, if you have a special chair in your office, I didn't know that this is a issue with your back. You could have brought the chair here and sat on the chair and argued. It's so much more comfortable.
No, that's very kind of your lord. One must suffer, my lord, the traditions of this court. May I just sit down and place this note?
Yes.
Requires a lot of courage, feel very unwell, anyway.
Anyway, my lord, those things should not be told to the court. Now, my lords, kindly come to section 23(2). The Supreme Court, the supreme governing body, would exercise all the powers provided by the 1920 Act. That's page 12, Placetum C. This is the distinction between external and internal. It's a misunderstanding of how universities are run. Sir Ashutosh was Chancellor, my lord, of Calcutta, and he took a very prominent view, my lord, in developing Calcutta institutions at the Calcutta University. Now, my lords, I come to section 23, my lord, your lordships will say, see that in the 1920 Act, only Muslims, my lord, were members of the court. The court is the supreme body. Now, my lord, I've already dealt with section 24-25. What is said, my lord, between place F and G is a little sentence. This provision clearly shows that the final power rested with the Governor General. Now, my lord, that's the Chancellor. And of course, his role completely went, my lord, because he appointed only the first Vice Chancellors, etc. But somebody had to do it. Now, my lord, the whole import of this is at the page 13 at the bottom. If anything, some of the important provisions to which we have already referred shows that the final power in almost every matter of importance was in the Lord Rector and the Governor General in Council. Now, my lord, this is misunderstanding the template. The rector disappeared, my lord, and became the visitor. Do visitors have that kind of right to supervise? Very importantly so, my lord. Then, my lord, if your lordships will come to place C, my lord. So, my lord, the internal part is mentioned in 14, but I come to place C. The annexure to the 1920 Act gave the names of foundation members of the court, numbering 120 who were all Muslims and who were to hold office for 5 years. Then section 9 was deleted, my lord. Now come, my lord, to page 15. The next substantial change was made with the proviso of 23(1). This is done in 1951, my lord, where while the court becomes the supreme body, it need not be all Muslims. Now, my lord, there is a decision of this court in Gandhi Faiz-e-Azam, Krishna Iyer, my lord, with a dissent, that the fact that you place other people on your board doesn't mean that you lose your minority character. Just as Justice Das says sprinkling of in TMFI. I'll show those, my lord, judgments as far as required. Then, my lord, if your lordships will come at 16, place F. I must say, I'm more relaxed, my lord. I'm very grateful for your lordships. Sorry, my lord, I apologize. Now, my lords, kindly come to F. We shall proceed, that's the third line, just opposite L, on the assumption that the present petitions that Muslims are a minority based on religion. Had he looked at the entire act, my lord, he would have realized what the purpose of the act. Now, my lord, if your lordships will come over the page, we come so, my lord, there is really no dispute that they're a minority. And Aziz Pasha says so in so many words. We accept that it's a minority. We accept the connection with MAO. MAO, my lord, was just the AMU was just the alter ego, my lord. It is a continuity of the MAO Act. Now, my lord, kindly come to page 18.
Page 16 and 17, they say that words establish and administer must be read conjunctively.
I'm coming to that. Of course, my lord. But as I said, these are the rights that flow from Article 30. The indicia, what is a minority, numerically, historical circumstances, the nexus, which St. Stephen's and others see, that is the important aspect of which goes to recognizing a minority institution. Established and administer are the rights that follow. So now, my lord, 17, your lordships will see at A. The words establish and administer must be read conjunctively. It reads to give the minority to administer an institution provided as it has been established by, provided it has been established by it. So the more important point is establishment, and the right to administer will flow from it. That's important, my lord, because Justice Vancho recognizes, but where does where does it get knocked out? On the first stage. You were established by statute. So he says, where is your right to administer? It's not there at all. Then, my lord, there is. Now, this, my lord, is all conjunctive and this, I won't go into that. Now, my lord, the three questions on the top of 18 in Aziz Bhasha was whether it was established by the minority, first question, whether the right to administer ever vested in the minority, and even if the right to administer properties came to be the university, the minority before the establishment of Aligarh University, whether it had surrendered, it has been surrendered when the Aligarh University came to be established. Now, my lord, there's a very interesting, at C, just top of C, that paragraph. Before we do so, we would like to say educational institutions are of a very wide import and would include university. Now, my lord, this is a contradiction. On the one hand, you say if it's established by statute, then you have not established it. And this is of far-reaching consequences. And then the UGC Act, my lord, specifically says you must do it by statute and by no other method. And then, my lord, this was not disputed on behalf of the Union of India, and therefore it establishes, it may be accepted that a religious minority had so, my lord, I'm sorry. template overtaken. No, sorry. Now I was at 18. That there are very, and would include university. Now, my lord, this is fundamentally important for the future and what Aziz Basha lays down. If universities can only be established by statute, then the first part of Aziz Basha says you have not established it. On the other hand, universities are part of the minority character. And the Union of India, my lord, accepted that a religious minority has the right to establish a university. Fundamentally, my lord. Now, my lord, we come to the famous St. David's College. When I show seal white to your lordships, the Lord, he says one line seems to have been relied upon. Now, we have looked at it carefully. The reason why David's College was decided in this way was that although it had the right to confer degrees, it was not recognized by the Royal Charter. So this is, my lord, the support from St. David's, which I'll show to your lordships, my lord, if required. And this has been a stinging my lord, controversy raised by various jurists. Then, my lord, kindly come to the important part of the University Grants Commission at the bottom of that page. It says at H, my lord, the importance of recognition dependent on the will of the government cannot be minimized. Now, my lord, all the decisions on Article 30 say that you cannot hold back recognition. So Section 6 is right. Now, my lord, at the bottom of that page, it was only in 1956 that Section 22 of the UGC lays down the right of conferring degrees shall be exercised by a university established or incorporated by and under a central act. When we were arguing Yashpal, Mr. Dwivedi made the very important point that this must be read conjunctively. That is, established and incorporated. Then, my lord, kindly come to B. It was only thereafter that no private individual or body could grant a degree in India. Therefore, it was possible for the Muslim minority to establish a university before the constitution came in force, though the degrees would not be recognized. Now, where are we now? Because we have to take into account the UGC. What is Aziz Basha's implication? On the one hand, you say universities can be minority. On the other hand, you say if it's established, I'm sorry, you have not done it. Then, my lord, kindly come. Next paragraph, there was nothing in the 1920 Act to prevent the Muslim minority, if it chose, to establish a university. This is wholly incorrect. It couldn't have. It could only happen, my lord, by charter or statute. And this is true, my lord, of many acts that we see in that area. The 1922 Delhi Act, which makes, for example, says St. Stephen's is a constituent college. But if it did so, the decree was not bound to be recognized by the government. Well, this is now, my lord, history. You have to recognize it. Recognition cannot stand in the way of a minority character. Then, my lord, it says in the absence of recognition of the degrees, it may not have attracted students. And that is why we find the constitution came into force. Most of the universities were established by legislation. Incorrect. All the universities were established by legislation. Now, my lord, then Aligarh University was also in the same way established by legislation, provided the Section 6, the degrees, diplomas, and other distinctions granted or conferred by persons of the university shall be recognized, as are the corresponding degrees, diplomas, and other academic institutions. Then, my lord, it is clear that even though the Muslim minority could have established at Aligarh 1920 University, it could not insist that degrees granted by such university should be recognized. This is wholly, my lord, at variance with the jurisprudence of your court. Recognition and affiliation, TMA Pai says, cannot stand in the way of the minority character. Then he says, my lord, at G, the enactment of Section 6, therefore, when the Aligarh University, above F, was established by Section 6, its decrees were recognized, and the institution was brought into existence, which could not have been brought to existence by private individual body, or individual could not insist upon recognition. But the more important part is the enactment of Section 6 is a very important circumstance, which shows that the Aligarh University, when it came to be established, was not established by the Muslim minority. For the Muslim minority could not insist on the recognition. This is all passé. Your lordships have said otherwise. Recognition is fundamental. When your lordships looked, my lord, at the colleges and the schools, when they were denying recognition, your lordship said, no, your recognition cannot stand in the way. Then, my lord, very important is H. It is true, as it is clear from the 1920 Act, that the nucleus of the Allahabad University was the MAO College, which was till then a teaching institution under the Allahabad University. The conversion of that college, if we may use the expression in the university, was not by the Muslim minority. It took place by virtue of the 1920 Act. This, my lord, is the crucial point. I take your lordships now to D, my lord. Now, my lord, at D, it may be that the 1920 Act was passed as a result of the efforts of the Muslim minority, but that does not mean that Aligarh University came into being under the 1980 Act, 20 Act, and was established by the Muslim. This is the error. All along you are saying universities can be minority institutions. And at the same time you are saying the intervention of a statute will deny you that status. Then, my lord, I come to this. No. It says, my lord, that funditio incipiens and funditio perfections. My lord, this means, the incipiens means at the process of granting recognition. And, my lord, the proficience means, my lord, perfecting it. In actual fact, it's wrong to rely on only the latter. Because AMU was there at the beginning, that is at its inception, and also, my lord, later on when it was established. Now, my lord, we come to a very interesting area at the bottom of page 20. What does the word established use in Article 30 mean? If your lordships will go over the page, it gives the different meanings of the US to settle firmly, to fix unalterably, to establish justice, to make or form as to establish a uniform rule of nationalization, to found or create, to regulate as Congress shall have the power to establish post, to found, recognize, confirm or admit. Now, my lord, it mentions the Oxford Dictionary, and it says establishment has a number of meanings: to ratify, confirm, to settle, to found, to create. The big criticism of Mr. Sirvai and others is there was a plethora of meanings that you could establish, use, but you didn't. You picked up one, which is there, my lord. We are of the opinion that the purpose of Article 31 means to bring into existence, so that the right given to the minorities to bring into existence as educational, and if they do so, to administer it. We have therefore to see what happened in 1920 and who brought the university into existence. Now, my lord, Mother Provincial, which is a six-judge bench judgment, confirmed by TMA Pai, uses the word found, which I'll show to you. It's fundamentally different.
What is the distinction between found and bring into existence?
My lord, bring into existence, according to the judgment, is to incorporate, whether by charter or otherwise. Found means you take into the antecedent circumstances. And Mother Provincial at para 8 says that even if a single individual philanthropic does this, it will be found. We're not, my lord, in the process of just a legal interpretation, my lord, of 30. We're in the process of looking at the entire process. And he's absolutely right in looking at those Latin terms at the instance of preparation and, my lord, at the instance, my lord, of founding. Now, my lord, kindly come to the history again at Placetum F. From the history we have set out above, it is clear that those in charge of MAO College, the Muslim University Association, and the Muslim University Foundation Committee were keen to bring into existence a university at Aligarh. There was nothing in the law to prevent them. But that's not true. But if we say found, the connection can be seen between the past and the present. Then comes, my lord, a very important part at H. It may be accepted for the present purposes that MAO College and the Muslim University Education Association and the Muslim University Foundation were institutions established by the Muslim minority. Then over the page, it says it was under, then, my lord, but if the MAO College was to be converted into a university whose degrees were bound to be recognized by government, it would not be possible for those who were in charge of MAO College to do so. We come to the same conundrum, my lord, that to establish means to establish by statute. You accept everything about the minority background. Then, my lord, if your lordships will come to Placetum F. So the lordships did not examine the 51 and 65 Act properly. Now, my lord, come to F. Nor do we think the provisions of this act can bear out the contention that it was the Muslim minority which was administering Aligarh University after it was brought to in existence. It is true that the proviso to 23(1) says no person other than Muslim shall be a member of the court, which was declared to be the supreme body and was to exercise all powers. We've already referred to the fact that the select committee was not happy about this provision and only permitted it in the act out of deference to the wishes of the prepondering Muslim opinion. How is the select committee, my lord, if the majority is there? How does the minority discomfiture, my lord? The important point here is, if you prove you established, then only you will administer. It is not necessary, my lord, that the governing body must necessarily have Muslims. Gandhi says. Nor is it necessary that all the students should be Muslim. Kerala Education Bill and TMA Pi. Then, my lord, if your lordships, after, my lord, noting that the members of the court, the supreme body, shall all be Muslims, this is what is said at place C on page 23. It will then be seen that besides the fact that the members of the court had to be Muslims, there was nothing in the act to suggest that the administration was in the Muslim minority as such.
Wrong.
We have to see the act, my lord. The two templates, my lord, that I have given to your lordships. The external template and the internal template. Then, my lord, if your lordships will skip all this about Article 26 and come to one part, my lord, 24F. But the right under 26 will only arise where the institution is established by religious denomination. It is in this event it can claim to maintain it. Now, my lord, TMA Pi specifically says 26 is the right. And you say you can't prove establishment, therefore your right disappears. Then, my lord, I won't trouble your lordships with '27, my lord, is important. No, this was an argument based on Article 19, but what is important, my lord, if we see the act, my lord, there is a transition in section 4 from MA college surrendering its rights. So, my lord, we have MAO college, all its property goes, the old students who are there have to sit the exam. This continuity, my lord, according to this judgment, is broken by the 1920 Act. And therefore, we come, my lord, to place C. Therefore, when the Constitution came into force, there was no property which was held by the Muslim minority. As such, for the property vested in the corporate body, the Aligarh University. Even assuming that before 1920, the property was surrendered, which was the property of the Muslim minority, the 1920 Act put an end to their rights. What transitions take place? You have a college, it gives all its property, it gives everything. And that is the continuity, which is broken now because of the view of the 1920 Act. No, it is now established that you don't surrender your minority status. So, my lord, these are the contradictions in TMA Pi. It was a Muslim minority, Muslims in Basha. Go to the act.
It's important.
Actually, two act comes later.
1920.
Another way. Where is my copy? For the acceptance. Skeptically. In Aziz Bhasha. On the one hand, it says a university can be a minority. On the other hand, it says if it's established by statute, it can't be. It says the nucleus comes from MAO, but we can ignore it. Now, this, my lord, is simply unacceptable in the light of St. Stephen's and others. The antecedent history is important. And this, sorry. Okay. We'll come to that. There are films on lip reading, my lord. Now, my lord, kindly bear in mind that if Aziz Basha is right, no university can be a minority. It's contrary to legislative practice, but my lord, no institution. And a deemed university which has been recognized as a minority was established, in the words of Mr. Dwivedi before Yashpal, by or under the statute. All deemed universities acquire a statutory character. Now you say it's established, a deemed university is established by and under. This implication, my lord, is of important significance. Now let me take your lordship to the 20 Act. Volume 3G, my lord. Three G, my lord. PDF 4? PDF 5. I've learnt a new phrase, my lord, PDF. Is your lordship there, my lord? First read the preamble, my lord. In the 1920 Act as it was, my lord, there have been changes in 81. Whereas it is expedient to establish an incorporated teaching and residential university at Aligarh and to
There is a Muslim.
Muslim university at Aligarh and to dissolve the societies registered under the Societies Registration Act, which are respectively known as the Mohammedan Anglo-Oriental College and the Muslim University Association, and to transfer and to rest in the university all properties of the said societies and of the Muslim Foundation Committee. This is the continuity, my lord, that is there. Now, my lord, just have a look at 2H, my lord, which says university shall mean Aligarh Muslim University. Then, my lord, if you come to 3, I've already explained, my lord, this Governor General power is part of the first template, not the second. Now, the continuity your lordships will see in section 4. Here, my lord, the societies known as so-and-so shall be dissolved, and all properties of the movable and immovable, and all rights and powers and privileges of those societies, and all properties movable and immovable, and all rights and privileges of the Muslim University Foundation shall be transferred and vested in the university. This is the continuity recognized by this act. There would have been no act, my lord, but for the foundation coming here. Then, my lord, all debts, liabilities, and obligations shall be transferred to the university, which is 2. All references in any activity, in any enactment to either of the said societies shall be construed as references to the university. Any will, deed, or other document, I won't read all of it, shall be construed as if the university was therein named instead of the society or committee. Then, my lord, subject to any order of the court may make, the buildings belonging to the MAO shall continue to be known and designated immediately before the commencement of this act. Finally, my lord, subject to the provisions of this act, every person employed immediately on the commencement of this act in MAO shall hold employment under the university by the same tenure, same terms, and then, my lord, pension, as if the act had not been passed. Now, what is section 4, my lord? How do we interpret it? Aziz Bhasha, my lord, interprets it negatively. Our interpretation, my lord, taking into mind the antecedent history, which your lordships now accepts, has to be taken into account. St. Stephen's has a huge, my lord, para on this. It says even the motives, my lord, if you see it, St. Stephen's, even those motives show its character. Now, when Siddharth Shankar Ray was arguing before the Allahabad High Court, he gave 3, my lord, volumes on the motives. I'm not going to trouble your lordships with that one. But clearly there was an institution which in continuity became a university. Then, my lord, 5 come to 2, my lord. All this is ignored, my lord. The Muslim character is ignored. 5, subclause 2, at the bottom of page 6. This is the purpose that has been ignored by Aziz Bhasha, which I mentioned when I basically, my lords, summarized what was wrong. And your lordships will see some of the points in the written submission, my page
14 to 25.
14 to 25. I'll quickly go through that when the time comes, my lord. Now, my lord, what does 2 say? To promote Oriental and Islamic studies and give instructions in Muslim theology and religion, and to impart moral and physical training. This is completely ignored. Then, my lord, then, my lord, if you come on page 7 to 512, after it says to do all other things, at the bottom of that page it says Islamic learning and Muslim theology to promote the interests of the students. This is the purpose of the act. My lord, 7, if your lordship comes to page 7, 12. At the bottom of 12, my lord. I don't want to read the whole of it, my lord, it's irrelevant. What is relevant is Islamic learning and Muslim theology. Now, my lord, we come to section 6. One is, my lord, the power to grant degrees. And that 6 says shall be recognized by the government. This is an absolutely correct, my lord, interpretation of Article 30. Of course, it must be recognized by the government, as all the decisions say, otherwise it will be valueless. Then, my lord, 7 mentions how the government, my lord, said 30 lakhs should be given by an endowment. The nexus, my lord, is there because it is these institutions that have to provide the 30 lakhs. Now, over the page, my lord, there is an interesting provision which, of course, would not stand in our feminist jurisprudence, my lord. Didn't want to disturb your lordship's thinking. Now come to 8, my lord. This won't stand, but it says something about the women are exempted. Now this will not stand, my lord. But the understanding at that time was this was linked with Muslim jurisprudence. And now it is deleted. Then, my Lord, 9 shall have the power to make, provided that instruction in Muslim religion shall be compulsory in the case of Muslim students. This is consistent, my Lord, with Article 28. And then, my Lord, what happened is this was deleted and a choice was given. I remember, my Lord, when I went to school, whether I should attend church or not. They had to get my father's permission. And I'm very grateful I did. I wasn't in the choir, but like your lordships, my Lord, I could sing Christmas carols. Now, my Lord,
You also have to give a letter.
Others.
Sure. Doing well or badly? this, my lord, is what was the purpose of the act? Now, all these provisions, my lord, show what the purpose of the act was. Grant education to Muslims. Even forcing Muslims, my lord, to attend. Now, that, of course, is deleted. Then, my lord, kindly come to 12, which is very important, on page 8. The university shall, subject to the statutes, power to maintain and establish intermediate colleges and schools within such limits of the Aligarh district as may be laid down in the ordinances for the purpose of preparing students for the university, and may provide instructions in the Muslim religion and theology. Its purpose, my lord, your lordship is very right, my lord, in saying that we can't have these minority institutions as ghettos. Agreed, my lord. They must be institutions of excellence. They must conform to the general law. And nothing in this act takes that away. Then, my lord, if your lordships will come to 13, kindly just 1 second. The Governor General shall be rector. This is therefore, my lord, the rector who becomes analogous to the visitor. And that's where my template comes in. The external authorities and the internal authorities. And my lord, I'm informed by my colleagues that this is verbatim in all the other acts. That is section 13.2. For the rector, read visitor. We've given some examples in volume 4, my lord. I'll take your lordship. So, my lord, 13 and 14 are taken care of. And your lordship wanted to know what the internal aspects were. Kindly come to page 10. It says, the following shall be officers. So, my lord, the rector and the visiting part are not officers. That's the external part in my templates. Then, my lord, the successors to the first chancellor shall be elected by the court. The court, my lord, under section 23 was solely consisted of Muslims. Then your lordships will see 18 pro-vice chancellor shall be elected by the court. 19, the successors shall be elected by the court. 20, the pro-vice chancellor shall be appointed by the court. And now we come to the most important section, section 23. 22 also, my lord. You will see that the visitor is not an authority of the court. 22. Now, 23, my lord, is very significant. And although noticed, the implications have not been worked through. "23, read the proviso. As far as the proviso later went, but as far as the 20 Act is concerned, my lord, and the purposes of the Act are concerned, it says, provided that no person other than a Muslim shall be a member thereof. And this continued till 1951. Now, this is, my lord, very important when you come to administer. The court was hands-on, my lord, in the administration of the university, as is clear from subsection 2. The court shall be the supreme governing body of the university and shall exercise all the powers of the university, not otherwise provided for in the statutes. So all this, my lord, is there with the supreme body which consists of Muslims. Today there are non-Muslims, my lord. But the point is, this was the tenor of the 1920 Act. And then your lordships will see in 2, we're only concerned with the recommendations, that's the end of 2, my lord, of the Lord Rector. Now your lordships, my lord, have personal experience of what it is to be a chancellor, what is a visitor, etc. Your lordships may be non-interfering, different from chancellors today, my lord. One day that issue will come before your court also.
It's already before.
Already, I'm sorry.
We know that.
Now look at 3, my lord. Subject to the provisions of this act, the court shall exercise the following powers and perform the following duties. This is the supreme body consisting of Muslims. Making statutes and or amending or repealing the same, of considering ordinances, of considering and passing resolutions on the annual reports, of electing such persons to serve on authorities of the university, such of as prescribed by, of exercising such other powers and performing such other duties as may be confirmed or imposed by this act or statutes. The purpose of this is administration will stay with the supreme body. Things have changed a little bit, my lord, but the supreme body part remains the same. Then, my lord, I want to take your lordships to the statutes and ordinances. Kindly come to page 12. Look at J, my lord, on page 12. The instruction of Muslim students in the Muslim religion and theology. The next is important, my lord. The establishment of intermediate colleges and schools and all other matters by this act, which by this act or are to be or may be prescribed. Now this is referring to section 12, that within a radius of the mosque, you should establish these institutions. Then, my lord, kindly come to 28. Come to the proviso, my lord, at the bottom. Provided that no statute dealing with the instruction of Muslim students in the Muslim religion and theology shall require to be submitted or approved for approving. Now, my lord. Page 14, my lord. As an argument, my lord, in subsection 5, the continuity is established. Those students who are in MA college may continue with their degrees. Now, my lord, kindly see the first statutes which are important. The first statutes, my lord, are there in page 16. So this is in statute number 8. The court shall, subject to the provisions hereinafter contained, consists of the following members. Kindly come to class 2. The persons named in the annexure shall be foundation members. The annexure, my lord, which I'll show to your lordship, was completely Muslim. On page 24, I'll come to that. I don't want to get into all this. So, my lord, the continuity is again established on page 19 at the top of subclause 3. The graduates are there and who have been educated in the Mohammedan Anglo-Oriental College and are members of the association recognized for this purpose by the Act. For, my lord, 20 persons elected by the Central Standing Committee of the All India Mohammedan Educational Conference. So, my lord, the link, my lord, with the foundation is here. Then, my lord, kindly come to subsection 6. It's very important, my lord, that the statute has to be read in a way in which Aziz Basha did not read it. And Basha did not even look at this. And Basha ignored the purpose, which is writ large over this. Now, my lord, kindly come. 30%, subclause 6, 33. 9 persons to represent Islamia colleges and other Muslim educations not under the control of the university. And then, my lord, 15 persons learned, then 9 persons learned in the Muslim religion and Oriental studies. Then, my lord, kindly come to the Executive Council shall have 30 members. And 3 is important, 6 other members to be elected by the Academic Council, and 20 shall be elected by the court. Now remember, the court, my lord, is all Muslim at that point in time. We've seen 23 provisos, my lord. Then, my lord, kindly come to 22. Top of the page, 2 persons elected by the court. Just mark these, my lord. It's just, the purpose is self-evident and control is self-evident. This is in the Academic Council. Now, my lord, come to 19. This was there in the original act, my lord, and the original statutes. I won't read all of 19, my lord, but kindly come to subclause 9, 10, 11, up to 11, my lord, up all the way down. What does it say? What shall the departments be? Sunni theology, Shia theology, Islamic studies, Arabic language and literature, Persian, Urdu, law. These are the few institutions in India that protect Urdu, which, as your lordship knows, in the 8th schedule is important. When I went to Pakistan, my lord, they have protected Urdu in a way in which we haven't. Of course, I have a quarrel with the 8th schedule, my lord. English is now an Indian language, whether we like it or not. It is. You look at the literature, you look at the poetry, you look at everything, my lord, all the proceedings of this court. There's no point taking this anti-colonial view that English is as much an Indian language and developed as an Indian language. My friends in England, my lord, used to say, you've twisted the English language and adopted it as your own, which is true, my lord. And as Mr. Sibbal points out, we do it better than them. But anyway, my lord, that's not the point. Then, my lord, no. 21, my lord, at subclause 2 on page 23. Graduates of other universities who have been educated for the last 2 years at the Mohammedan Anglo-Oriental College. Link again. Then, my lord, kindly come over the page. And we see the foundation members who are part, my lord, of the court. I won't read out the names, my lord, your lordship will just note them. Lord, we giving degrees through first Calcutta and then Allahabad.
Was affiliated to Calcutta.
Affiliated and also
Affiliated with
Allahabad, that's right.
From Surat also, there's somebody from Surat.
So, my lord, I'm sorry. Very good.
It can, minority college, it can get affiliated to a university and get a degree from there. But in the case of a university, that cannot happen. So if you want, and if you, without a university degree, you can't get employment. So the real problem is if you say that I should have continued as a minority institution, nobody would have been employed. Because you have to get a degree, and that degree has to be recognized. So if you are a university, it's the act itself that must confer that. This is the issue at the heart of the problem.
Section 6.
Your college was affiliated with Allahabad
Correct.
University, was getting
I am saying that as a college, but once you create a university, it can only be done by statute. There is no other way to do it. Basha says you can have a university, but that degree will not be recognized. But that's not the answer to the question. Because if that is not recognized, why would you have a university? I'm just.
No, the importance of Aziz Bhasha is saying that universities are a part of Article 30. It says so in so many words, and that they have a right to be recognized by a minority. If that is so, my lord, we can't say tertiary education, my lord, is beyond the scope of 30. Now, the fact that there were degrees through affiliation is really irrelevant now, because of the negotiations that took place. You take my property, you take my people, you take the students, you take everything and the staff. Because it was essential, my lord. Of course, there was no Article 30, my lord. But apply Article 30, my lord, to and Aziz Bhasha under the 20 Act. The whole point is the purpose of the Act was Muslim in character. And the purpose is nowhere to be found in Aziz Bhasha. Now, my lords. Now, my lords, I just note the pages, my lord, I just want to take your lordships, my lord, to my submission at page 61,
Page?
volume 1A.
What page, Mr. Devan?
61. Sorry, 60. Shall I continue after lunch, my lord?
Yes, we can resume after that.
But I want to upload my submissions.
Certainly. Give them to the notary councils, they'll make them a part of the compilation.
Mic check. 1, 2, 3.
I'm sorry to keep all of you waiting. Actually, both Justice Khanna and I were in a meeting with the members of the bar, senior advocates designation. So there's something very important to the bar. So yeah, just the preliminary
This
groundwork which has to be done.
This point one must ask for a trade-off. As I mentioned earlier. But I'm very fearful of that. Because when we were arguing 370, they gave me water and I said whiskey. And I got calls from Singapore and all over India. Was there whiskey in the glass or not? Now, my lord, I want to take your lordships to the statement of objects and reasons. I'm still on the purpose point, which is in volume 4A.
Oh, submissions really look at, please have a seat. Please have a seat, doctor. Look at the antecedent history of the institution, one, the purpose of the statute, and place the provisions of the statute in the backdrop of the antecedent history and its purpose. And the mere fact that a statutory provision somehow restricts what a minority institution could otherwise do in the absence of the statute would not be a ground to deny its status in an Article 30 institution.
That's the point about recognition also.
And recognition and affiliation,
Yes.
you have to apply according to you for recognition, otherwise your degrees will never be recognized.
Even for schools, my lord, where they depend on aid.
That's the submission, really.
Even there,
Colleges too.
colleges. In fact, the whole part of Inamdar relates to aided and unaided. That the unaided don't lose their minority character. May I sit down?
Yeah, yes,
I'm
Doctor.
very sorry, I'm very
No,
touched.
please have a.
Volume 4A, my lord, page 88.
You were reading actually volume 1A, page 60, I think.
I'll come back to that.
Okay.
I'll come back to
So we look at volume.
that. 4A at page 88. Your lordships have it.
Yes.
Now, this is the statement of objects and reasons to the 1920 Act.
Yeah.
4A.
Yeah,
That's right. Lord, the printed version is on 87. This is easier to read because it shows the nexus, my Lord, that I was talking about. The Muslim University Association, having requested the foundation of a university and certain funds and properties being available to this end, it was proposed to dissolve the association and the Mohammedan Anglo-Oriental College, Aligarh, and to transfer the property of those societies to a new body called the Aligarh Muslim University. The present bill is designed to incorporate this university, to indicate its functions, to create its bodies, and to define its functions. It also secures the university's assurance of a permanent endowment to the government.
And the necessary power of control.
Part of control. The university and the teaching residential type, in accordance with the recommendations of the Calcutta University Commission, the university will not include intermediate classes, but the university will have the power to maintain intermediate, establish and maintain intermediate colleges and schools at Aligarh. They're all Muslim. The degrees conferred will be recognized by the government. Special features of the university will be imparting for Muslim religious education to Muslims and the inclusion of the Department of Islamic Studies. The bill provides for the making three. The general terms, my Lord, on page 89 of the bill and statutes have at various times been discussed with the representatives of the Muslim University Association. That's the purpose. Now, my Lord, I'll come to my written submission, my Lord. I'll flag that very much. I have, my Lord, in my summary, what the reference is really about. I've given a short paragraph and then
60 of your written submissions.
this is my written submission.
Also, when we use the expression, Article 30 uses the expression establish and administer.
Yes.
Now, there is no absolute standard of administration that you must administer 100%, and even that 100% will be an elusive standard.
Right.
So, to make Article 30 effective, we do not have to postulate that the administration by the minority has to be an absolute administration. In that sense, today, in a regulated society, in a regulated state, nothing is absolute. virtually every aspect of life is regulated in some way or the other. So merely because the right to administer is regulated by statute and to a certain extent is not untrammeled, does not detract from the minority character of the institution.
That's the point we were making. I'm grateful. But that is the essential point. And then you add of their choice.
Of their choice. And it's established means you must have founded it, as you said.
Right.
And that is a little more objective, but administration in that sense, there's no statutory definition or constitutional definition of the expression administer. Yes, the courts have held what administration means. But if that right of administration is regulated itself by statute,
Lord, it can't be that it'll all be Muslim, Muslim, Muslim. It just simply cannot be. Because after the Constitution, all the universities have a liberal element in them. Please give representation to students, representation to teachers. All that is there, my lord, in our university statutes.
three things are very clear. You don't have to be administering only religious courses. You can be administering a purely secular education institution.
That's right.
That's one. Second, the law is not that you have to admit only students of your community. You can admit students of all communities without forsaking, because it's a right of establishment and administration. So that's the second important ingredient. And therefore, a minority institution does not lose that character according to your submission merely because various aspects of its existence are regulated by statute, including aspects relating to the administration of the institution.
Right.
The state in public interest is entitled to regulate, or the state legislature or parliament, as the case may be, is entitled to regulate administration in public interest to ensure that the conditions of service of the teachers are fair, that the staff of the institution is not maltreated or not deprived of basic conditions of service. There'll be a variety of administrative requirements which the state can impose, or the minimum requirements for the allotment, for the conferment of degrees, standards of examination, standards of syllabus, the curriculum. That's all regulated by the state, but that does not detract from because that applies across the board, irrespective of whether you are a minority or a non-minority institution.
That's right. And that's why I said in the beginning, we accept that it must be institutions of excellence and all the other regulatory features, statutes must apply. With one caveat, my lord, which is repeated again and again, that the right to administer does not mean the right to maladminister. That's very important. It comes in Kerala education and then, of course, my lord, in TMFI. Just, my lord, to get this purpose, etc. point dealt with, my lord, page 60. Because in our respectful view, the reference has to be culled out by your lordships. Because it mentions the Minority Act, it mentions the University Act indirectly. So all that has to be culled out. We've said, was Aziz Bhasha right in accepting the antecedent historical data on AMU's Muslim character, but denying its constitutional significance while deciding the issue of its minority status, which is at variance with St. Stephen's, Proust, and Path? Because they recognize, my lord, the antecedent history and just give it the go-by. Because that point about nexus and continuity, my lord, origins. What is the origin? In St. Stephen's, they go right through the origins and they even say, you look at the buildings and they are quite clearly Christian in character. Now, my lord,
just one thing. This you are raising it in the context of Aligarh Muslim University. What will be the position post the enactment and enforcement of the Constitution?
yes, my lord, of course.
With regard to universities which are established or founded thereafter?
My lord, what we have seen is that a large number of deemed universities under the UGC Act and the other statutes, they've been declared to be minority institutions despite Aziz Bhasha. And therefore, my lord, we have to look at this now also, as I will point, through the constitutional lens, which is the question your lordship put to me on Article 30. And my lord, liberal education has to be combined with religious education. May I proceed now?
Yes.
60, my lord. I have dealt with this, but just to, as a preface to the next argument, the Mohammedan Anglo-Oriental College was the nucleus of the appellant university. This is what Basha says. The founders had from the very beginning desired to incorporate MO colleges as a university and grant degrees that are recognized by the government. The Muslim community largely contributed the funds necessary to incorporate MAO into a university. The founders had long negotiations with the government to introduce a legislation and establish the the MAO college. Nonetheless, both courts have held now in Allahabad that the appellant university was not a Muslim university. The word establishment, my lord, is followed almost mechanically. Now come, my lord, to the antecedent history. I'll run through it very, very fast. I realize time is of the essence. Now, my lord, come to 61. We have divided, my lord, the antecedent history into three phases. From 70 to 77, where the earlier idea of setting up a university for the Muslim community for the betterment and advancement took place, and when MAO college was established. From 77 to 1910, the Muslim community rallied to convert MAO university, and due to their efforts, the government in principle agreed to convert the college. And from 1910 to 1920, where the founders from the Muslim university actively engaged with the government and succeeded in their desire to convert and incorporate the MAO college. Now, my lord, the vision, my lord, in the first phase, I'll just quickly run through it, my lord, your lordships may read it through because I don't want to go too much. In the first phase, my lord, in 1870, Sir Syed established the Committee for the Better Diffusion and Advancement of Learning amongst Mohammedans. The committee sought the views of the Muslim community as to why the Muslims were not availing Western education, and it was found that this was due inter alia lack of religious education, non-consultation with minority Muslims. Thus, the idea of an educational institution managed by Muslims for the benefit of Muslims with religious instruction received support. Then 1871, my lord, the MAO college is established. Over the page in 62, when the committee says, the object of the committee shall be to collect funds towards the establishment of the college, particularly one for the education of the Mohammedans as suggested by the Central Committee for Better Diffusion and Advancement of Learning amongst Mohammedans. Now, my lord, the committee resolved to establish the Madrasul Ulum, madrasa being a term for education at Aligarh, which was subsequently inaugurated. This was the first step realizing the vision of a university. Then, my lord, the Madrasul established the MAO college. And then, my lord, I'll just say what the Governor General says. From the seed which we sow today may spring a mighty decree whose branches, like the banyan of the soil, shall in their turn strike firm roots into the earth and send forth the new vigorous sapling. That is, the college may expand into a university. So this is the other element, my lord. As your lordship pointed out, it's not just Muslim education, it has to be more than that. And after the constitution, certainly so. Then, my lord, rules and regulations of MAO say object to the college shall be primarily the education of Mohammedans. Then first only the Muslim community was involved in the administration. And I mentioned the select committee and the rules for guidance of the MAO college. Over the page, my lord. The second phase, my lord, consists of the Syed 7.6.1, seeking the government's support for the Muslim community and looking upon a degree as a means to success and government jobs as recorded by Altaf Hussain Hali in his biography of Sir. In further, my lord, of the written address was presented to the college fund committee to the viceroy. By far the greater portion of your funds and endowments naturally derived from members of your race and creed. Someday when our endowments are richer and our schemes are completed, we hope to ask to confer upon us the legal status of an independent university. The funds, my lord, come from. Then, my lord, there's recorded in this book, my lord, in 1998, a memorial fund was created to raise funds for incorporating MAO College, and this proved to be a success. 1,27,000, my lord, was an enormous amount in those days. I remember, my lord, my amount we used to get, my lord, in my school was only 2 rupees per week. It was huge. So we have got to inflation-proof this. Now, my lord, at the bottom of that page, those and other efforts by the Muslim community resulted in substantial funds collected for the establishment of the university. Then, my lord, there was an address that was given when they met the viceroy. His ideals and those of Sir Syed with regard to the expansion of the colleges are the view is the ultimate development was the formation of a Mohammedan university, of which the idea was strongly supported by the late Justice Mahmood, son of Sir Syed, and by Morrison, our last principal. The former may be indeed to have said to have formulated, if not fathered, the university scheme, while the latter developed it in numerous writings. Now, this is the great Justice Mahmood, my lord. As your lordship knows, the Privy Council saw his judgments and said, you please become a High Court judge. After that, he delivered, I think, 8 significant judgments, and then he resigned to get himself involved, my lord, in this process. Now, my lord, we come to the third phase, which is important. In 1911, the Committee Takmili Mohammedan University Foundation Committee, now this is important, was constituted for converting MAO College into a Muslim university with the Raja Sahab of Mahmoodabad as the president. On the recommendation of the Government of India dated 1911, the Secretary of State approved in principle the establishment of a university at Aligarh, subject to provisions of adequate funds and control. 1911 again, the Government of India specified that a university could be established only through a bill in the Legislative Council. Over the page, my lord.
Yes.
Then, my lord, in 1911, page 65, or rather PDF 65, where an institution styled as Mohammedan Oriental College was founded by Aligarh in 1875 under the leadership of Sir Syed Ahmad Khan Bahadur, with the special object of promoting the diffusion of Western science and literature and of training the character of students by a scheme adapted to meet the special requirements of the Muslim community. Both, my lord, a liberal education as well as, my lord, the demands of the Muslim community. And whereas from the beginning, the object of the founder and the Muslim community was to raise such college to the status of a university, whereas a memorial had been presented to the government by the trustees of the said college and other representatives of the Muslim community, praying for the erection of a Muslim university and inviting attention to the advantages a university would have, which would confer on their community to the inadequate representation of which their community had in existing, to the enthusiasm which their own university would create amongst the Muslims. And then, my lord, and to the need for religious teaching and protection. So, my lord, the fact, as was pointed out in an interruption, that MAO College could still get degrees, that's not the only point, my lord. The point is of substance, a liberal education along with the concerns of the Muslim community. Then, my lord, 1911, the Secretary of State says sanctioning a university at Aligarh will be a source of enlightenment and prosperity that the Muslim community and will crown and continue the hopes of Sir Syed Ahmad Khan. The negotiations continued, my lord, and then your lordships will see that 5 lines from the bottom on 65, in an intervening letter dated 9/10/1912, The education members specifically mentioned that the movement was started without reference to government and that the hope of Sir Syed to convert Aligarh into a teaching and residential university, and his hope has been repeatedly expressed since the leading Mohammedans and others are connected with the college. Also note that the draft constitution stated from the beginning the object of the founder and the Muslim community was to raise the college to the status of a university. 1915, my lord, practical shape was given to this, and the MAO annual report, I won't read it, my lord, and it says the conversion should be there. Then, my lord, 8 is important on page 66. The Muslim community raised 30 lakhs for the university as required by the government. So this is the interaction, my lord, the money was raised by the Muslim community. And this, my lord, you find reference in the statute and in section 7. Now, my lord, after extended negotiations, the Muslim University Bill was prepared in 1990, referred to the Select Committee. The Select Committee report submitted its report to 2/9/19 at 2nd of September. The Muslim community's predominant role in the university administration is clear from the debates. In reference to the constitution of the court, we have retained the provision that no person other than Muslim shall be members. We have done this because we understand such a provision is in accordance with the preponderance of Muslim feeling. Then, my lord, the matter comes to the Legislative Council. Before putting the question, I would like to add congratulations to the Muslim community on the passage of the bill. I've come specially this morning to preside that I may add good wishes, etc. Then, my lord, the University Act of 1920 was a statement of objects and reasons, which I've read to your lordships, my lord. My lord, it's just not the degree, as they said you could do it before 1920. It's a wholesome university with liberal education and the concerns of Muslim theology, etc. Now, all this, what Aziz Bhasha does, it says that in the Select Committee, there was some disagreement on this. That's not how to read a Select Committee, my lord. I pointed that out to your lordships. Now, my lord, I 7.8 is just important because, my lord, your lordship doesn't look just at the de jure situation, also the de facto. And this we have pointed out that the members of the first court were Muslim, 8 to 12 members were Muslim, every chancellor to date has been Muslim, 34 out of 37 vice chancellors have been Muslim. The vast majority of the members of the court, executive council, academic council, and executive council, my lord, have all been throughout Muslims. Now you want to take all that away, because when appointments were made by the government, they made sure that the appointments conform to the Muslim character. Then, my lord, I have already read because St. Stephen's looks at the emblems, my lord, there. I just want to do 7.9. My lord, when this was argued in Allahabad, Siddharth Shankar Ray, my lord, gave 3 volumes, and the court said, yes, of course it is Muslim in appearance, but we are bound by Aziz Bhasha. Now, the history background is architecture of the building, such as a deep green color, Quranic inscription, clearly show the Islamic character. Photos were shown to evidence to the division bench. The emblem of ANU contains a Quranic verse. The university has a university mosque. After the amendment was allowed to establish halls, hostels, special centers, specialized laboratories, only within 25 kilometers of the university mosque. The university employs muezzins. At its inception, the MAU had departments of study, Sunni theology, Islamic studies, Persian and Urdu, studies for Islamic medicine, all that I've read to your lordships. I don't need to read it further. Now, all these documents, my lord, are in there. I don't want to take your lordships further. I've just summarized them. And to answer the argument sort of raised, It's just degrees. You could have done it before. No, you wanted a university. And you wanted a liberal education. Take it. So I've done the face now. Promise somebody, he seems to be. Your Lordship's point, it can't be full and complete control. It can't, my Lord, especially after the Constitution. And administer, my Lord, has to be considered. Now, my Lord, I'll read some judgments, my Lord, including TMA Pi and Mother Provincial. This, your Lordships will find in volume 5A. This will answer, my Lord Justice Khanna's question to some extent. Pre-Constitution, post-Constitution, the change and the requirements. Now, my Lord, Kerala Education Bill, I'll be in 5A, I'll be very fast, my Lord. Starts at page 4, but I'll go straight, my Lord, to 71. I'm sorry, my Lord. I missed out, my Lord, on page 60. That is, my Lord, somewhere halfway down. There is no reason why the benefit of Article 31 should be limited only to educational institutions established after the commencement of the Constitution. The language employed in 31 is wide enough to cover both pre-Constitution and post-Constitution institutions. Then, my Lord, 61 is very important, my Lord. This is about 15 lines from the top. The sentence beginning, to say that an institution which receives aid on account of its being a minority educational institution must not refuse to admit any members of the other community only on the grounds therein mentioned, and then to say that as soon as such an institution admits such an outsider, it will cease to be a minority instrument, is tantamount to saying that minority institutions will not, as minority institutions, be entitled to aid. Now comes the important part. The real import of Article 29(2) and 31 seems to be that it clearly contemplates a minority institution with a sprinkling of outsiders. Let me pause here, admitted to it. My Lord, that sprinkling now after St. Stephen's has gone up to 40%. So St. Stephen says you can go to that extent. And of course, my Lord, this is modified by TMA Pi says it may not be 50%, it will depend on the needs of the institution. Then, my lord, by admitting a non-member into the minority institution does not shed its character and cease to be a minority institution. Indeed, the object of the conservation of distinct language, script, culture of a minority may be better served by propagating the same amongst non-members of the particular community. In our opinion, it is not possible to read this condition into Article 30, subclause 1. Then, my lord, page 62, comes the important, my lord, pronouncement of the words of their choice. This is, my lord, just below halfway. Lord, I'll go just halfway down. The key to the understanding of the true meaning and implication of the article under consideration are the words, as your lordship got it, of their choice. It is said that the dominant word is choice, and the content of that article is as wide as the choice of the particular minority may make it. The ambit of the rights conferred by Article 31, therefore, have to be determined. It should be referred to be determined on misprint by Article 31, and therefore to be determined on has therefore to be determined on a consideration of the matter from the point of view of the educational institution. Now, all this, my lord, somehow Kerala Education Bill was before Bhasha. The foundation had been laid here. And the analysis of Article 31 is missing, my lord, in Aziz Bhasha. It just goes by established or administered, doesn't look at the question of choice. Now, Kerala is a 7-judge, my lord, decision, binding, my lord, on TMA Pi for the interpretation of 30. Now, my lord, 71. This is halfway down, my lord, because now, my lord, where it begins, we have already observed that Article 31 gives 2 rights to the minorities to establish and to administer educational institutions of their choice. The right to administer cannot obviously include the right to maladminister. The minority cannot surely ask for aid or recognition for an educational institution run by them in unhealthy surroundings without any competent teachers possessing any semblance of qualification and which does not maintain even a fair standard of teaching and with teaching matters subversive of the welfare of the scholars. It stands to reason that the constitutional right to administer an educational institution of their choice doesn't necessarily militate against the claim of the state to insist that in order to get grant, the state may prescribe reasonable regulations to ensure the excellence of the institution to be aided. Learned Advocate General, Attorney General conceded that reasonable regulation may certainly be imposed. So both aspects, my lord, excellence, these are not ghettos, my lord, excellence and application of the general law. Then, my lord, if your lordship will come to 72. It says, my lord, at the top of 72, what the state says, I have money and I shall distribute it, but I shall not give you any of the, unless you surrender to me your right of administration. Then the state must not grant aid in such manner as will take away the fundamental right of the minority community under Article 30. Then, my lord, about 1/3 from the bottom. No educational institution can in actual practice be carried out without aid from the state. And if they will not get it unless they surrender their, unless they surrender their rights, they will by compulsion of financial necessity, they will be by Yeah,
They will be compelled to give up.
they will be compelled to give up their rights. So, my lord, this whole question of recognition, aid, you don't surrender rights. 76. This comes to the question of recognition, my lord. Aziz Bhasha says, look at the section 6. They're saying recognition, that's by the state. Now, my lord, about just last 1/3.
Commander is willing to desire the education.
ठीक है, Nikhil. I'll go straight to the recognition point. Then, my lord, about just below halfway, without recognition. Aziz Pasha says you got recognition from the state, therefore you surrendered your rights. In a sense, it's implying that. Without recognition, therefore, the educational minorities established or to be established by the minority communities cannot fulfill the real objects of their choice, and the rights under Article 30 cannot be effectively exercised. The right to establish national educational institutions of their choice must mean the right to education, to its right to establish real institutions which will effectively serve the needs of their community and the scholars who resort to their institution. There is no doubt that there is no such thing as a fundamental right to recognition by the state. But to deny recognition to educational institutions, except upon terms tantamount to the surrender of their constitutional right of administration and their constitutional right of administration, where are we? Of
Administration of the educational institution.
Of the educational institutions of their choice, and is in effect to deprive them of their rights under Article 30. So, more recognition in the 1920 Act can't be read as something that the government gave you, but it is your right. It can't take it away. And it's quite clear here. We repeat that the legislative power is subject to fundamental rights, and the legislator indirectly take away and abridge the rights which it could not do directly, and yet will be the result of the said bill containing any offending clause becomes law. Now, my lords, this, my lord, is the foundation of the interpretation of Article 30. Totally ignored by Aziz Pasha. So this is a 7-judge bench, my lord. There is something in the Kaveri, my lord, reference, where your lordship said, is it binding on us or is it not, my lord? I think the wisdom now is that even the reference puts points of law. Now, my lord, on 94, I come to Siddharth Bhai. Give me the absolute platform.
Mr. Dhawan, my question was slightly different.
Yes.
My question was this
But your lordship's voice is so soft.
Okay, now is it clear? Probably.
Yes, much better.
Yes, okay. My question was slightly different. It arose from your argument that now for the university, a statute is required.
Yes.
Now the establishment post the independence after the 1956 UGC Act section will be under a statute. Now, when that is so, will this argument still hold good? What your argument is you're raising today? Until, because there is the legislature then who's creating or enacting the statute.
Yes, my lord.
Then will you say the foundation is not by the statute? Yes, there could be cases of colleges because colleges can be established by minorities. There's no difficulty on that. But your argument with regard to university, because it's to be established by the statute, then what will be the position?
Lord, I had indicated to your lordships that established cannot be given the narrow meaning that it's established by statute. I indicated that you had to look at origins, you had to look at nexus, you had to look at numerical. This is the criteria. Now, if you take it all into account, the question is, will the UGC Act, my lord, override Article 30? No. The fact that there is a requirement of statute will not offend Article 30. And then, my lord, as I indicated, Mr. Dwivedi was amicus, my lord, in the Yashpal order, where he said you interpret the UGC Act as by and under. So every statutory authorities, deemed universities are covered. They are under, by or under. Therefore, my lord, you cannot have a university. You cannot have a university, my lord, without degrees, without it. And therefore, my lord, you can't read down with the UGC Act, you can't read down Article 30. And then your lordships have seen in the reference in 2019, the National Minority Education Act says you have a right to a minority institution. So, my lord, your lordship's question may lead to an exclusion of tertiary education. Then the question of their choice comes up. I don't know if I fully answered it.
Yeah, that's right.
And my lord, the private universities have come up, all under statute.
As long as the statutes permit them, they will fall in this. That's now, if this university is set up under the statute, if the statute itself says it's a minority university, they'll obviously, because the funding is done by or the establishment is done by the minority community, and minority is a much wider term, not restricted only to religious minority.
Lord, the statute will never say.
That's where the problem will come up.
No, my lord, it doesn't come up. Because in St. David's, my lord, it is certainly true of England that you have the right to grant degrees, but you don't have it doesn't come in the Royal Charter. Your lordships will take the statute as it is and then analyze whether it's a minority institution. That is antecedent, my lord, to establish and administer.
If I may say so, brothers, establishment, if it is correlated to the statute, that's it's a wrong way to look at it. What the statute does is recognize, not establish.
No, I'm talking about the initial establishment.
I'm saying, brothers, establishment is not establishment through an act. Brothers, you establish something, it is recognized by the act.
So you're saying that this statute itself is a recognition of what you have.
Yeah, it's the recognition. The establishment happens. Whereas it's how does it get recognized? Because the statute says you'll get a degree. That's the act of recognition. Without that, you won't get a degree. That's the answer.
Lord, the establishment of the fact that the statute does establishes or brings into being, which is our mother provincial. The fact that it brings into being will not militate, my lord, under the minority right under 30. We can't whittle down Article 30 just because the statute exists. And that is, my lord, a defect in Aziz Pasha, followed, my lord, by the Allahabad High Court. Now, if I'm right, my lord, the learned Chief Justice does not want me to go into the Allahabad decision, which is under appeal before your lordships. So that would take a very long time. It's a wonderful decision, my lord, which says that dinner jackets have been exchanged for a sherwani. Great fun to read, Chief Justice Roy. Is it saffron or is it green? That's what he asks. He's moving towards.
The legislature due to propose the constitution
arises from your lordship's query. Is 30 establishment, the term establishment, to be read in a narrow sense so that it can be taken away by statute, or in a wider sense to define what a minority institution is? The subsequent decisions of the court, my lord, say read it in the wider sense. You go back to the history, you try and figure out what the nexus is. So ultimately, if your lordships are going to give Article 30 a narrow meaning, by back to Aziz Pasha. And everything goes through. All tertiary education cannot be minority.
At a certain level, what happens when a statute takes over an erstwhile institution, whether it's a school, a college, and gives it a statutory form? The statute really converts it into a body corporate, because what was erstwhile maybe just a society governed by the Societies Registration Act is now given the statutory character of a body corporate with a permanent seal and permanent succession. Does that conversion of a society into a body corporate, so to speak, under the provisions of the Act, deprive it of its minority character? Or is that merely only a matter of form to convert the form which was a society into a body corporate? Or does that change in form completely destroy the minority character of the institution?
Lord, our respectful submission is, it is a mandatory form, my lord. That is,
You see the long title of still remains. It's the soul of the changes. Should I recognize it? It's actually objects and reasons.
yeah.
What are
लखनऊ रहने दो।
1920 का पढ़ दिया
नहीं, yes, लखनऊ का।
See.
And that's placing nature. My lord has spoken. So there, my lord.
Nice, very sensitive.
No, my lord, this is a fundamental question that your lordship has to resolve. Aziz Bhasha says universities can be minority institutions. It also says they must be done by statute. And if by statute, they go. This is the unresolved question, my lord, which your lordship has to examine. And along with something which says at the end of Article 30, of their choice. Therefore, you have to read establishment as not the be-all and the end-all of Article 30. It has to be read as a whole where it says of their choice. And Aziz Pasha says your choice can be a university. And both in those days and now, my lord, if there is a statute, so will it all disappear, my lord? The entire, my lord, of tertiary education will disappear, minority institutions. And therefore, my lord, read the whole of Article 30, which is, as I've already said, my lord, the words are in Kerala University. Because the narrow, everything turns on establishment. That is why Mother Provincial says it should be to found. You take all the factors as to what is founded by the minority. It may not be in the statute. In the Delhi University case, not two cases were before the court. The Allahabad Agricultural University and St. Stephen's. And you don't find that in the statute necessarily. But you have to see who founded it. And your lordships, as soon in Patro, as soon as you say Christian, they said it's good enough to found. So don't, my lord, in my respectful submission, use established, because as your lordship puts it, it's not a matter of form alone. It's a matter of enabling form. That enabling has to be there to come under 30. Then, my lord, we get to the questions of substance. And that is the argument, my lord, we are advancing. My lord, let me take your lords to page 94, Siddhaj Bhai.
Yes.
I'm sorry, I'm going as fast as I can. My lord. Super speed. Now, my lord, page 113. It's a 6-judge bench, my lord. Just as Kerala was a 7-judge bench. My lord, at end of the first para, Kerala education case, therefore, is not an authority for the proposition submitted by the Additional Solicitor General that all regulatory measures which are not destructive or annihilating of the character of the institution established by the minority, provided the regulations are in the national or public interest, are valid. This argument is rejected. But you go to the extreme of saying, was it annihilative? That's the wrong question. Then, my lord, the next para, the right established by Article 31 is a fundamental right in terms absolute. Now, my lord, this was tweaked by TMA Pai to say national interest must come in. But as far as, my lord, Aziz Bhasha is concerned, this was binding. Now, my lord, I come to it is intended to be a real right for the protection of the minorities in the matter of setting up of an educational institution of their choice. The right is intended to be effective and is not to be whittled down by the so-called regulatory measures conceived in the interest of not of minority, but of the public and nation as a whole. Now, this, my lord, was before the court. Now I come to the next question, my lord, which your lordship, my lord, the Chief Justice has put. That what are the implications, my lord, of the actual substance of these institutions? The implications are it must be an institution of excellence. And this your lordship will find on page 114. This is the famous dual test, my lord, which is adopted by TMA Pi as well. Such regulation must satisfy a dual test, the test of reasonableness and the test that it is regulative of the educational character of the institution and is conducive to making the institution an effective vehicle of education for the minority community or other persons who resort to it. Now, my lord, I come to Mother Provincial, which has emphatically been accepted by TMA Pi. Don't disturb the boss. Now, my lord, this is on page 163. And the relevant paras, my lord, which have been affirmed in TMA Pi are 8 and 9. I'll take your lordship straight away to them. Page 166. Look, this is actually a spy master, my lord. It's spying on what we say to each other. Now, my lord, kindly come to 8. It's very important.
You have to switch off the mic. Or tell us to switch off your mics. We have that control here.
I know. Your lordship is right. Now, my lord, kindly come to 8 at page 66. Article 30, what it means. Article 31 has been construed by this court. Without reference to those cases, it is sufficient to say that the clause contemplates 2 rights, which are separated in point of time. This is important, my lord. The first right is the initial right to bring into being of an institution.
Just jump the line. First right is the
Bringing into being of an institution.
Sorry, the first right is the initial right to establish institutions of the minority choice. Now, my lord, when we read Article 30, we don't go straight to establishment. That's a consequence. It's my right. We first, my lord, examine whether it was a minority institution or not. Then, my lord, establishment here means the bringing into being of an institution, and it must be by the minority community. The next sentence important. It matters not if a single philanthropic individual with his own means founds the institution of the community at large, contributes to the funds. The position in law is the same, and the intention in either case must be to found an institution for the benefit of the minority by a member of that community. It is equally irrelevant that in addition to the minority community, other minority or even from the majority community can take advantage of the institutions. Such other communities bring in income and they do not have to be turned away. Now come to 9. This now, my lord, I'm dealing with after Aziz Bhasha. I've dealt with before Aziz Bhasha, Siddharth Bhai and Kerala Education. Which para of TMA Pi?
Yes.
Now, my lord, 9. The next part of the right relates to the administration of institutions. Administration means management of affairs of the institution. The management must be free of control so that the founders or their nominees can mold the institution as they think fit and in accordance with their ideas. I'm sorry, my specs are not working. Of how the interests of the community in general and the institution in particular will be best served. No part of this management can be taken away and vested in another body without an encroachment upon the guaranteed right. Now, in para 109, my lord, of TMA Pi, this is affirmed. And it's a sea change, my lord, from the establishment version, my lord, in Aziz Pasha. You first look at, is it a minority institution? Then you go further. Now, my lord, sorry. Now, my lord, if your lordships will come to 10, this is where it says such regulations do not bear directly upon management, as although they may indirectly affect. Yet the right of the state to regulate minority institutions, education standards, and allied matters cannot be denied. The minority institutions cannot be allowed to fall below the standards of excellence. Where are we here? Expected of educational institutions, or under the guise of the exclusive right of management to decline to follow the general pattern. And this applies, my lord, also to management. The university doesn't become insular. That's very important that your lordships have mentioned this. And nobody is arguing it should be insular. Then, my lord, I'll take your lordship straight away to St. Stephen's. And then TMA Pi, and I'm done with this part.
Page 384.
Page 384.
Para 34 at page 415.
How do we approach it? It is there in Proust to some extent and Patro. But I'm coming straight to St. Stephen's. Now, my lord, kindly come to page 4.
415.
No. Please come to 413, my lord. Para 29. There's a subheading, Origins and Purpose of St. Stephen's College. I'm sorry if my reading is somewhat erratic, my lord. I'll try and be more careful. Now, my lord, Delhi University in this pleading has neither denied nor admitted the minorities of the college. Then, my lord, it says that they argued that it was done by a foreign mission from Cambridge and therefore it was not entitled to the benefit of 31. 413, page 29, para 29. Then, my lord, it goes through, and I'm not going to read it, my lord, because these are the factors that you take into account. The 81, a Christian missionary college came, members were in residence, the Cambridge Brotherhood wanted to establish a Christian college, then all that is mentioned and the condition to the contrary is therefore not correct. The purpose of starting the college, this is halfway down, my lord, of this paragraph, could be seen from the report of 1878 to Cambridge Brotherhood, and it states that the students, after leaving St. Stephen's Mission College, join non-Christian colleges and lose touch with Christian teachings. The case would be otherwise if we were to send them from our school to a college where the teachings would be given by Christians. That's at plus E, my lord. Now come, my lord, to 31, which is important. Because these are factors, my lord. There are environmental factors, but they are important. And in Aligarh, my lord, it is writ large that this is an Islamic institution. 31 says, originally the college building was housed in hired premises paid by the SPG. A new building was eventually constructed by the Society for the Propagation of the Gospel, wherein the foundation stone bore the following inscription: to the glory of God and the advancement of sound learning and religious education. The new building was then, my lord, started in December 1881, and on the front of the porch, at the top of the parapet, a cross in bas relief was displayed, and under the brackets, and Die Gloriam, which has been inscripted since adopted by the college. Today, the new college building campus has also a large cross on top of the main tower and the rod to perpetuate and remind the students the motive and objective of the college, the glory of God. This all emanates, my lord, from found. The primary right is found. The consequential rights, my lord, are established and ministered. Now, my lord, 34 sums it up. It would thus appear that since its foundation in 1881, St. Stephen's College has apparently maintained its Christian character and would be evident from its very name, emblem, motto, establishment of a chapel, and its religious instructions in the Christian chapel for religious study. This is the scope of inquiry. Now, my lord, come to 417. $41. It was contended that St. Stephen's College, after being affiliated to the Delhi University, had lost its minority character. In other words, when you come under statute under the Delhi Act of 1922, do you lose your character? But that's the statutory provision. Then it says the argument was based on some provisions of the Delhi University Act and the ordinance made thereunder. It was said that the students are admitted to the university and not to the college as such, but we find no substance in this contention. In the first place, it may be stated that the state or any instrumentality of the state cannot deprive the character of an institution founded by a minority community by compulsory affiliation, since Article 31 is a special right of minorities to establish educational institutions of their choice. The minority institution has a distinct identity, and the right to administer with continuance of this identity cannot be denied by coercive action. Any such coercive action would be void, being contrary to the constitutional guarantee. The right to administer is the right to conduct and manage the affairs of the institution. This right is exercised by a body of persons in whom the founders have faith and confidence. Such a management body cannot be displaced or reorganized if the right to be recognized is to be recognized and maintained. So recognition doesn't stand as reasonable restrictions are permissible, but regulations should be of a regulatory character and not abridge the right under 31. So, my lord, here we see the intervention of statute. As a constituent college, it was by or under the Act of 1922. Then, my lord, if I may come to page 442. 422. Para 54. The minorities were I'm sorry, my lord, I didn't realize your lordship was conferring. The minorities, whether based on religion or language, had the right to establish and administer educational institutions of their choice. The administration of educational institutions of their choice under Article 30 means management of the affairs of the institution. This Management must be free from control so that the founders and others, nominees, can mold the institution as they think fit and in accordance with their ideas, how the interests of the rest of the community and the institution in particular will be served. Then, my lord, I would like to come. Sorry?
Standards of
Then, my lord, the next line, my lord, I'm sorry, the standards of education are not a part of management as such. The standard concerns of the body politic is governed by considerations of the advancement of the country and its people. Such regulations that do not bear directly on the management, or they may indirectly affect it. The state, therefore, has a right to regulate the standard of education and allied matters. Minority institutions cannot be permitted to fall below the standards of excellence expected of educational institutions. Now, they cite the cases, my lord, which I needn't cite, because they say this is now confirmed by a string of decisions.
Both the decision of Chief Justice Hidayatullah in Mother Provincial and the judgment of Justice Jagannath Shetty in St. Stephen's, they don't cite the judgment in Basha. They refer to all the other, because perhaps Basha in that sense is a little out of alignment with what was laid down in the other decisions. As you see, Justice Hidayatullah, that passage you read out, and actually para 54 is a restatement of what Justice Hidayatullah says in para 9 and 10.
Absolutely.
But Justice Hidayatullah refers to all the earlier cases, but doesn't refer to Basha.
Lord, Basha is referred to in St. Stephen, but it doesn't do anything to it.
Yes. Stephens refers to Siddharth by Bombay
Para
Education.
24, page 40.
But Basha is on a fact situation.
Yeah.
I think my learned friend is arguing his case already. Now, my lord, Basha Now, my lord, kindly just turn to 410. on page 410. Incidentally, it mentions it in para 24, and para 25 says it's been superseded by Patra.
Sarah?
My lord, para 24 on page 410. I won't read all of it, my lord, because this we've done. Then, my lord, 25. A couple of years after Aziz Basha, this court had another occasion to determine the nature of an ancient institution claiming to be minority. The decision, as per reported in Escopatra, since it appears to be in close parallel with the case at hand, it would be useful to have the contentions. Then, my lord, the contentions are there. And then, my lord, what happened in para 27? On appeal, the judgment of the High Court was reversed by this court mainly on two grounds. That's at page 411. The High Court did not pay sufficient attention to that part of the evidence supplied by the petitioners, which was sufficient to justify the claim that local citizens had participated in the establishment and the school in question. Indian citizenship not being a condition of the application of Article 30, the protection thereunder could not be denied on this basis. So, my lord, here we have a clear statement that if you take Patro into account, you have to look at the evidence. And this court reversed it on that basis. Now, my lord, back to
424.
may I continue, my lord?
Yes.
Page 424. Bottom of the page, paragraph 59. Lays the foundation for TMA Pi 1. The need for a detailed study on this aspect is not necessary. The right of minorities, whether religious or linguistic, to administer educational institutions and the power of the state to regulate academic matters and the management is now fairly settled. So that regulation to bring it up to an excellent institution is there. The right to administer does not include the right to maladminister. The state, being the controlling authority, has the right to regulate all academic matters. Regulations which will serve the interest of students and teachers and to preserve the uniformity in standards of education among the affiliated institutions could be made. The minority institution cannot claim immunity against the general pattern or standards or general laws, such as the laws relating to law and order, health, hygiene, labor relations, social welfare legislation, contract, tort, which are applicable to all communities. So long as the basic right to management is not taken away, the state is competent to make regulatory legislation. Regulations shall not have the effect of depriving the right of minorities to educate their children in their own institution. That is a privilege which is implied by the right conferred in Article 30. 433. Now, Lord, 433, para 80.
That you're not admitting only students from your
And
own
those others who resort to it.
as the others who resort to it.
That's the important part, my Lord of Kerala. And now here. Otherwise, what will happen, my Lord? It will become a communal institution. We don't want that. It's a kind of protection, my Lord, And I've said in St. Xavier's, it is needed there to avoid discrimination against the minorities. I won't go through St. Xavier's, my lord. It's a very long decision. Now, my lord, kindly come to 80, my lord. Broadly speaking, 80 says, reiterates Kerala Education Bill.
Right.
And therefore, my lord, now come to 88, my lord. Am I done? I have, my lord, just two more quotations from St. Stephen's, which if your lordship will indulge me, when early at 4 o'clock I will read and do TMA by tomorrow.
Yes.
Now, my lord, 88, since the receipts of a state at 435 does not impair the rights of Article 31, the state can lay down reasonable conditions for obtaining grant and aid for its proper utilization. The state has no power to compel minority institutions to give up their rights under Article 30, and then, my lord, Siddhaj Bhai. Then the regulation cannot change the character of the institution. Such regulations must satisfy that dual test, my lord, of reasonableness and excellence. Reiterated here again. Last time. Now, my lord, kindly come to page 439. At the bottom of the page, para 102. Lord, may I just read it, my lord?
Yes. So,
Your time controllers are here, my lord.
yes.
In the light of all these principles and factors, and in view of the importance the Constitution attached to protective measures to minorities under Article 31, the minority-aided institutions are entitled to prefer their community candidates to maintain the minority character of the institution, subject, of course, to conformity with the university standard. The state may regulate the intake in this category and due regard to the need of the community in the area which the institution is intended to serve. But in no case shall an institution exceed 50%. The minority institution shall make available at least 50%. Now, my lord, from trickling, we have now recognized 50%. Of course, TMIP says it depends on the nature of the institution.
Just read the last but one sentence once again.
Sorry, my lord.
Just read that last but one sentence, paragraph 102. The state may
The
regulate.
minority institution shall make available that bit.
Yes, yes.
At least 50% of the annual admissions to members of communities other than the minority community. The admission of such minority candidates shall be done perfectly on the basis of merit. Of course, in St. Stephen's, they said you can do an interview, which was crucial. Delhi University said you can't do an interview. And although it was a it is.
So please don't comment upon it.
So, my lord, I will stop here if I may. And thank your lordship for your gracious acceptance of my taking the chair.
We'll reassemble tomorrow morning.
Thank you.